my content. So a quick background about InfoSec Train. We have been here from 2016, and we are leaders in security and privacy training in India. So I'm gonna skip the marketing part and jump because I this agenda is purely for a knowledge purpose. So I'm gonna jump into my core content, starting with the DPDP Act. So Anas was giving introduction saying that data is the new gold. So data is the gold, data is the oil, and data can be equated to anything right now which is more precious, right? So because I think there has been a burst on AI, and the AI is rapidly changing us and our lives, the way we work as we speak. And we might witness a revolution like we saw with the internet. So, and it's gonna be a very interesting time, and the entire innovation which is gonna be fostered by AI is gonna have certain guardrails in the form of data privacy, and it requires a lot of thinking about it in terms of how do we handle it, and it's very important that we address the requirements, right? With that particular note, I feel like it's a time for us to understand the draft rules which have been released by the union government. And it's important for us to know what are those requirements and what are those interesting comparisons in terms of what are the areas which might need to be addressed and what are the areas which I feel are excellent from global data privacy laws perspective. So I'm going to go give you a complete coverage on the different rules. Okay, compared to many sessions you would have seen in the YouTube or other forums, which is just going to pick up the rule and just speak about it. But I'm just trying to give you a more comparative view, as well as I'm just going to speak my thoughts in terms of what this rule requires you and what it means for the organization and business to take it up. So with that, I'm going to start in terms of the first and foremost requirement in data privacy law is about giving a privacy notice. Okay. Anyone who has been implementing data privacy, so you would have definitely seen the most important segment of implementing data privacy program starts with transparency, correct? So transparency requirement requires organizations to speak about why they're collecting the data and what they're going to do with the data. And in terms of it, I usually gives that give a statement that it is more like a promise, like our currency note has a promise from the RBI governor. So this is a promise which you are going to give to the from a fiduciary to a data subject, right? So this promise is something which is very important because this is a promise you are going to be validated by data subject rights, and this is going to be validated by data audits. This is going to be validated by every possible inquiries or any requirements from the data protection board in terms of inspecting you, correct? So it starts with privacy notice, right? And people from the European Union, you can relate this to the information provision obligation, and although the terms could be different, but the intent is always the same, right? So what I've done here is I'm trying to give a comparative view between the privacy notice in the Indian DPDP Act rules versus the GDPR. And I'm trying to give you like what's different and what's something which is not addressed here in the Act. And I'm going to leave an important discussion around this. Okay, in terms of very first point which I want to clarify here is, if you see the coverage, right? The coverage speaks about privacy notice for consent based processing. This is a very drastic move from the traditional forms like GDPR laws, which gives you multiple avenues to process data. And in Indian DPDP Act, it has consent-based processing and other 9 legitimate use of processing. But what we need to look carefully between the lines is that the privacy notice has been explicitly highlighted only for consent-based processing. Whereas if you see GDPR and other data privacy laws around the world, it might focus on not only consent, but other lawful basis. Maybe it could be your contract, it may be your public interest, your legitimate interest. In all these cases, a very important requirement is information provision obligation, correct? So you may call this different words. Organization may not call this as a privacy notice, but those requirements of why we are collecting this data and what we are processing the data could always be presented in a form of terms and conditions in a contract, right? So the heading may not be there, but the requirements are usually captured, right? That is the most important part of any data privacy law. But something that is right now limited only for consent-based processing. The good part of the Indian law is it's focusing on consent-based processing, which says that for activities which organization decided that this is going to be consent-based processing, they need to be very, very sure about the requirements around it, starting with privacy notice, having an audit trail of your privacy notice along with the consent, and ensuring that you need to reproduce it, and in terms of whenever you're being challenged you need to provide it, correct? So these aspects are something which makes privacy notice and consent management a very critical task for the fiduciaries whenever they are implementing part of the requirements in the organization, right? So the scope is something very important that you need to be aware of. The clarity on language is almost the same. I don't see any big difference. In GDPR, you would have seen some specific emphasis which is given that you need to balance both your adequacy of the notice as well as the conciseness of the notice, right? So this is required because sometimes people can slap you with so much of content that you feel lost in terms of reading a privacy notice, or maybe sometimes they fill it with a lot of legal jargons and you might be tempted to just close it or give the permission right away, right? So that is something which I have seen GDPR explicitly call out, that you balance both your adequacy of a notice in terms of the content coverage as well as the conciseness of the information, correct? And in terms of the purpose of processing, I think I have covered it. And so it also has some specific areas which is to be covered in the privacy notice of the DPDP Act rule versus the GDPR. So if you see, some of the important elements, according to me, are not currently required part of the DPDP Act rules, right? For example, the purpose of processing could be called out, which could be a very high level statement in terms of the business purpose for processing the data, right? But it also need in GDPR that we need to look at the legal basis for processing the data. We often interchangeably use the word lawful basis and legal basis, and it refers that which exact lawful basis we are trying to map in terms of processing the data, right? Especially if it is a case of legitimate interest, right? It is important that we need to call out this in the privacy notice, because this is directly linked for the data subject to raise a specific rights associated with that. For example, right to object is very closely related to your right to link to the legitimate interest as processing, right? So that is what we call the legal basis. So I think if that is something clarified at later part of the rules, where it's not only the business purpose. For example, you are using the data for non-consent based processing. It's important to bring that clarity part of the transparency requirement. The next important part is the retention period. So retention period is again a very important requirement in terms of ensuring the storage limitation part, right? So usually the challenge is sometimes it's an ongoing business contract with the data subject. So you may not call out the exact period, right? So this is something which we know from the other data privacy law as well. If not for the retention period, at least for the criteria of retention. So this could be in terms of for an existing contract, or it's a legal requirement. So the criteria for retention is also something which the organization would generally address, right? So this is something which is completely missing in terms of the requirements. The third party sharing, which is the disclosure part, right? So in terms of sharing this data to a third party, okay, this could be your processor, sub-processor, could be your independent third party. So this is something which specifically gets called out part of the privacy notice in the GDPR is something which is not currently being mandated by the law in DPDP Act rules. Cross-border data transfer, a very important requirement, because what I feel is if this information is not provided to the data subject, the decision making, according to me, may not be a valid consent. Because if you're asking consent, and if you're not stating that this data might be traveling outside the country, this itself actually makes that consent a questionable aspect, because the data subject is not provided with all the required information, and somewhere it states that the cross-border data transfers are something a very critical aspect where the data subject needs to be known, right? If the data is bounded for any international data transfer, it is always an important obligation part of transparency to be called out, right? So consent withdrawal is more or less being covered in both these laws. Rights of individuals are there, but the 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 way we exercise data subject rights maybe needs a bit more clarity. And very important part, there are specific use cases like automated decision making, right? So this is not currently being addressed. If the processing is going to involve automated decision making, it's important to be called out, right? A part of the privacy notice. So the data subject again can make a very cautious decision whether they want to allow this data to be based on consent, or they might back out if they know that the data is going to be allowed for automated decision making. So people who are not aware about the word automated decision making, you can directly relate this to your artificial intelligence, right? So if my data is going to be subjected to artificial intelligence, and trust me, once the data goes into that black loop, right, black hole, so basically the data can never come back, right? So it's almost important for everyone to knew this, right, beforehand, before allowing my permission for the organization to use my data. So I need to know whether my data is going to be subjected for automated decision making, right? So personally, I feel this is something which should be required by the fiduciaries to call out part of the notice. And controller identity is something which is information for them to have a clarity about who is a controller, and in terms of the grievance or the data protection officer point of contact. Although this information is uh, mentioned in some other place, but I would call this should be brought within the scope of a privacy notice. So this is something which I feel are some of the aspects which are covered in the privacy notice of the Indian law. And there are few areas which might be still not there. And trust me, all of us have very important responsibility to call this out in terms of why we need this and how this is important for us, so that our voices are heard by the authority, so that we see the final version of the rules having these aspects as well. I see a hand raised.
So
Saurabh?
then, yeah, yeah.
Yeah, Saurabh. Yes, Saurabh.
Saurabh. So
Hi,
over to you, Saurabh.
Jay.
Can speak.
Nice to see you again guiding us. Jay, I had one question on the basically specifically on the Rule 3, Entry 4, Clause 3A, basically. And maybe you can take it for the Clause 3 completely. The question here is the when we look at this says that a notice shall be presented and be understandable independently of any other information that has been or is maybe made available to by such data fiduciary. So, for example, if I understand it correctly, but the privacy notice should be and has to be a whole in its totality. Like one document should be able to give all the context. But going by your statement, like you said just before a few minutes back, that this has been become a practice because companies are tend to make it so big that people basically forget to read it and avoid to read it and just simply go ahead and give the consent. So
Right.
operationally and the legally, the requirement seems to be conflicting each other because I have the cookies policy to give. I have the privacy notice from the other channels which I collect. So I need to give all the details in one show. If I start adding the cookies and everything in one notice, my notice will become like a 10, 12 pages kind of 13 pages kind of contract. But if I'm going into the layer and giving it like a hyperlink for the different sections for the different set of people, that way I can give you the concrete information for the people who actually need it. So how do I address this?
A very valid point, actually, to be precisely you are calling out an operational challenge, which many people only when they start implementing will realize this. Especially when uh, a channel specific privacy notice is one of the most effective way of collecting consent, and also in matured laws like GDPR they give you privacy notice strategies as well, preferring in terms of layered notice or in terms of just in time privacy notice. These notices actually facilitate more meaningful consent transaction, right? And also trying to break down the complexity of accumulating all the requirements in one place. It only leads to a part of saturation for the data subject, correct? The data subject could be not interested to know all these information in one go, and probably they may not understand the importance of it, right? And what rightly you said that this is a challenge where we typically see where in terms of balancing with the conciseness versus your adequacy of the notice, right? Very valid point, Saurabh, but we still don't have a clarity. And as you said, this is something we need to raise this. Having it in one place is only going to make it more challenging for the data subject. And the very objective might be questioned here, yeah, in terms of transparency. Thank you for the question. Sujata, uh,
Yep.
yeah,
Yeah.
please.
Hi, Jay. Happy New Year. How are you doing?
Hi,
So
Sujata.
it's
Happy
so
New Year.
nice
Yeah,
to see you on the platform. Yeah. So
thank you.
I have two one question and one comment, right? So
Yeah.
the comment is right. You rightly said language is so important, and when the content is too big in the privacy notices, generally people don't read. Okay, so they will just say, okay, I terms and conditions or consent I accept, but they don't know what problem they are getting into. Organizations are trying to protect themselves, but I don't know what sort of awareness people have with this, with this law. And some people maybe not even know what privacy means, how their data is going around, and how it needs to be protected, what they need to do, how they need to be vigilant, right?
Right.
That's a comment. I don't know what can be done to improve this awareness. So the question here is, if an organization does not adhere to these rules or to this regulation, what sort of a fine do they have?
Definitely, Sujata, I'll address the penalties part. Okay. So we have penalty section in terms of organization not adhering to the requirements. Okay. And the first part is about the literacy of data privacy law, and in terms of making people understand their obligations, their powers is something which we may take at least 4 5 years to gain this, right? So we might have started this journey maybe 15 20 years later. Okay, but I think there is an echo. I would request just keep yourself on mute. Yeah, thank you. So we might started this journey maybe 15 20 years later, but I strongly believe that the advantage is that we can quickly learn from others' mistake, right? So whatever people have faced those challenges, and I think with the way we embraced UPI and the way we embrace the technology adoption in terms of smartphones or even the IoT as we speak, India is leading this race somehow in terms of enabling this IoT based applications and business use cases all over the world, right? So I think this is going to have a fantastic impact, but in India, it's going to be a mix and match of bringing the people at par, getting them aware of what is required, and that is what we are doing here. We all 100 people have responsibilities doing it for a respective organization in our houses, making us realize how companies are using our data and our responsibility in handling it, right? Thank you, Sujata, for that question. I would see a couple of hands raised. So it was,
Thank you. Thank you, Jay.
thank you. Thank you. Thank you, Sujata. So, Mr. Subaraju,
Yeah, hi. Yeah, thank you so much for this session. It's been more insightful, it looks like. And initial point itself, I have several questions came into my mind when we talk about the the consent is one part. When you say that the consent in multiple languages it's supposed to be provided, but is it possible to read all the consent in all the 13 languages or 12 languages which is to be provided to a data subject or data principal, so that he will choose his own language and then put across this? This is a
Very
practical
valid question.
challenge.
Yeah, I was
Yeah.
about to address that. Okay, in terms of another important operation challenge, but you hit the chord already. So actually, how this is going to work is this is going to be given in one language. Okay, I think the language is a very sensitive topic, by the way, and the language could be one could be either Hindi or English, whichever is going to be the default language. Traditionally, how this websites are set up, right? So this is going to be in one default language, and after that, if someone feels that they are from a different language, then they can change this toggle option, right? For example, if you go to any European websites, you have
Translate
an
option.
option to change the translate, right? So very similar to that. So you want to change a privacy notice to an alternate language, you can toggle and select that particular language. But now the operational challenge is enabling those scheduled
Multilingual, yeah.
languages, which is the first challenge. And every concern needs to have an audit trail with a version of privacy notice. Now, saying that is very easy, but doing it in terms of the channels where we operate and in terms of enabling a consent audit trail mechanisms, these are all going to be very interesting tech challenges we are going to face. Okay, so but the intention is very good. I trust me, because this is one important part I like in the law, which is saying that try to be vocal in a language where people can relate to this, right? That one part which I have not added here is a very positive outcome from the law, saying that speak in the tongue of the people so that they know what they are up to, right? So I like this, but it comes with its own challenges, right?
Yeah, that's one thing. And second point, when we talk about the retention periods, so every organization has its own way of storing the retention periods of their cookies and other information when someone try to
uh
access the website.
Yeah, Subha, can you allow me, because I have this
Yeah.
exact slide on retention period. When we go there, we will hit that chord, because I
Yeah.
have multiple slides going forward. So I
Okay.
want to stick to notice part of the questions, and then I'm going to move on to the respective
Yeah.
slides, if that's
You
okay
Jay,
with
have
you.
you have another slide also on the data transfer part also.
Yes, I do have. I do have. I'm going to come to each of the slides one by one. All right.
Jay,
Uh,
Jay, oh,
All right.
yeah,
Thanks.
Jay,
Yeah.
we would like to add one more thing. You can see the comments in the chat box as well. If we see any of those relevant to the first domain which we discussed now, we can catch them as well. Like, what
yeah.
are your thoughts on legacy data impact on organization and the way ahead to handle if it is
Correct.
related to
That
that? Yeah.
legacy data part is again a very important question mark, because usually the lawmakers give a time period. For example, the law was clarifying this particular point, that if you had given a privacy notice before the enforcement date, right, and it is not exactly covering the requirements of privacy notice, which is mandated, you might be required to give a refresh privacy notice. This is the part of legacy data. Okay. So in terms of legacy consent, the best way to operate is, I think, if the notice itself is not fitting the bill, then obviously the consent should also be refreshed. Okay, so the legacy data, I think it's always on the safer side. Don't take that risk that your consent is valid, because you need to be 100% sure that the requirement of privacy notice is adhered, part of whatever transparency you're doing, part of the current processing. If that is taken care, plus in terms of the consent mechanisms, whatever you have is fulfilling the audit trail requirements, then probably you might not do any additional efforts. But in my thought process, it's always wise to refresh your notice and consent when the enforcement date. Okay, so that is something which I will definitely advise all my firms. Erase personal data upon data principal withdrawing the consent as soon as it is reasonable to assume that a specific purpose is no longer being served, whichever is earlier. Okay, that's a very interesting part, I will come to this data erasure. I will take it up little later. Okay. I'll just look at the last question for this topic. As nothing mentioned in the notice regarding cross-border data transfers, SCC's data subject can consider cross-border by transfer by default. I think
Exactly.
SEC is Ravi, very valid question, but SEC is something may not be effectively sort of proving the Indian concept of cross-border data transfer, because it's actually over and above. Trust me, if someone is doing a SEC for a transfer of data outside India, it's over and above what is required. But actually, the problem here is it's gonna be like the discretionary power of government, which is gonna say a whitelist and blacklist concept, right? So for the whitelist companies, they might come up with something like SEC in the further rules. They need to come up. They cannot skip the transfer impact assessment in terms of transferring outside the country, even though it's part of a whitelisted country. I would say a SEC-like mechanism is missing, but it might come up in the further versions. Okay, so that's my take. All right, so I think we have looked into it. It's already 35 minutes into the session. I'm going to jump into the other topics as well. Yeah, because
Gotcha.
we have 4-5 slides more to cover. So I'm going to quickly speak about this consent manager topic, right? So consent manager is my favorite topic out of the DPDP Act. The reason is this is a novel concept. I have never seen this concept in any other data privacy law, and that makes it interesting, as well as I'm bit unsure about how effective is going to be implemented in a short span of time. Let's take if the rules is going to be enforced in next quarter, and it might give you 1 year or 2 year time. And will we be ready in next 2 years for consent manager? I highly doubt that, because the way this is conceptualized right now, it will require a lot of infrastructure as well as integration between the different fiduciaries with the consent manager. And in fact, the revenue model of consent manager is also a very important question mark. Okay, so right now the qualification criteria are spelled out, but I'm still worried about the in terms of their revenue mechanism, right? So how they are going to make money, what they are going to do with enabling so much of powers to the data subject. It becomes a single point of contact for raising your grievances, managing your consent, your data subject rights. Everything is going to be centralized with the consent manager. But how they are going to make the revenue in terms of integrating, making your platform as a use. Okay, so how they're gonna make revenue out of it? How they are gonna be audited by the central government in terms of if they collude with the fiduciaries, right? In terms of making a secondary way of earning income. I'm just trying to say it hypothetically. I don't want that to happen, but these are the possible threats, correct? So we need to be aware of the strength is that it's gonna have a fantastic concept which enables a centralized consent management, right? It's going to facilitate transparency where the data subjects will definitely have visibility in one-stop shop mechanism where they can see all their concerns in one place, and they can change the decisions in one go, and they can raise requests in different platforms where they have given consent, right? So the conflict-free operation, right? The fiduciaries and the consent manager should almost have a specific conditions that they should not be related in terms of any business transaction. It almost becomes like a conflict of interest relationship, right? So that is something which needs to be taken care whenever the consent manager concepts becomes live. And the challenges, as I called out, will be the scalability part, and it also has the complexity of integration and the effectiveness of fulfilling those rights. What if this concepts creates challenges in terms of reconciliations, or if it creates more integration challenges where it more becomes complex for the people to know what I have withdrawn, what I have given, and what is the right spending. It creates a backlog of in terms of the real time data. There are a lot of challenges with that, right? So another important point which I wanted to cover here is about the digital literacy of the people, right? So, for example, the government is trying to exclude the digital non-digital data, right, which says that the entire act is about digital assets and digital resources. But there is a catch here. The moment I take a paper asset and I scan this, right, and I take a photograph out of this becomes a digital data, right? And this happens a lot in terms of our rural parts of the country, right? So will that segment of the country, will they be able to adopt this concern manager? Will they be covered in terms of the society coverage? The digital literacy is going to be one of the question marks which is going to be tested by the concern manager concept, as well as the privacy notice and consent mechanism as well. And the enforcement has some real-time challenges as well, right? So, but again, I really want this mechanism to become effective and real time, so we actually have an opportunity to teach the rest of the world how to do this in a most effective way, right? But it comes with its own challenges. That's definitely there, right? So that's about the concern manager. I'm not going to go into the other parts where they are going to say about the requirements of concern manager. I'm not focused on this, but I want everyone to be aware of this. Please don't anticipate this concern manager to be live in the early enforcement periods. Okay, this is going to take more time. This is my hunch, and this is going to take a lot of time for integrations to happen. So, which means there's going to be a lot of work to do on the back end, right? So, with that, I open the floor for questions. I see a question from Rohit. In banking, PIA is being taken and financial organization utilized it across for cross sale. Data subjects withdraw consent. How financial institutions deal with this? While RBA mandate to maintain the data of data subject for legal purpose. Okay, so two parts to it. RBI mandates data to be maintained for legal purpose. This is for the retention of certain legal and regulatory obligation. That is one part of it. But RBI doesn't ask anyone to do cross-sell of data, right? That's for sure. So what you need to understand is, if I get a bigger picture of your question, so the question is speaking about the the interlinkages between the data privacy law versus the sectoral laws. Will there be any conflicts which may allow ambiguity in terms of operations, right? One sectoral law is allowing you to have a different mandate versus the law is giving a different mandate. If that's the point of the question, and I can definitely tell you that that will not be the case, because the law of the land, which is the DPDP Act, will be the prime requirement in every case. And wherever sectoral laws are going to come up, or whichever is there, they will be amended to be in sync with the data privacy law. Okay, this is what has happened from our global understanding all around the world. So whenever there is a law which has been enacted at a country level, the sectoral laws will naturally get aligned with the country specific law. Okay, so that should definitely answer your query in terms of RBI as a regulator. You will see RBI might come up with some more detailed requirements for personal data management within the banking sector, and they might amend whatever is conflicting as of now. Okay, I hope that answers your question, Rohit. I see three participants have raised their hands. I see uh, Saurabh hand was raised before, or is it now? I'll go with uh, Saurabh Ja. Saurabh Ja,
Hi, hi there.
hi, how are you?
So I have my question. I'm doing very good. So I have my question
Yes.
in the area of consent only regarding the child consent. Given now there is an obligation for obtaining the verifiable consent of parent also. So don't you think, I wanted to know your opinion about taking the digital ID of parents and verification via digital locker? Like, won't this lead to mass surveillance in the hand of government? by government?
Okay, you're taking me to the trouble waters, huh? Okay, so I will anyways cover this topic. I have a slide on this. Okay, so I have a specific slide on children's concern. I'll answer it there. Don't worry, I'm definitely gonna answer it. Okay, so any
Sure.
other questions on this concern manager, Saurabh, or I'll go to Joyce.
Only this.
Yep.
Yes.
Yeah, Joyce.
Jay,
Sorry, Saurabh was there, is it?
yeah, on the consent manager, Jay, we can see there's another question from Samir. There's only mandatory for significant data fiduciary.
No, it's for everyone. See, consent manager is not something related to fiduciary or significant data fiduciary summit. This is something a completely different approach. This is for the data subjects. Okay, the data subjects will facilitate their consents. But if your question is, it is only limited significant data fiduciary to link with the consent manager. No, it is for all the type of fiduciaries. Okay, it's not just limited to significant data fiduciary. If I got your question right. All right.
Thanks,
So
Jay.
Saurabh Sharma,
Yes, sir.
yes, sir. Yeah.
And now, Jay, I'm coming from a legal background, and I do have a lot of confusions on that account. And I can see the rules is very much silent on many part of it. I'll still go ahead and pose the question. You are from the IT background, so I would expect or hope that if you can tell me on the operational part. First, being when we are talking about a consent manager in this provision or rule 4, in the act also there is a one right to nomination has been provided. So are we looking or can we gauge upon that this consent manager is nothing but a nominee of the data principles, or are we looking to have a two people fighting for one right like a consent manager as well as the nominee? That is the one part. Second, when we are talking about a consent manager, if it is not a nominee, definitely it will have to be act as an agent. How the nomination has to happen in that account, because I think rule should have provided the mode of nomination or the appointing the consent manager either by a power of attorney or by authorization letter or some validation document. So how do we do that?
Very tough questions for the government to answer right now because they don't have answers on that. Two questions which doesn't have any reflection right now in the law or the rule. So the first part is whether they are one and the same. No, they are not one and the same. Nominee is different, consent manager is different, but both of them are acting as an agent to the data subject. That is right. So my nominee could be different, my consent manager could be different, but both of them are allowed under the law to exercise the rights behalf of the data subject. Now, the difficult question is how does nomination works generally? The power of the power transfer can be indicated by a mechanism that can be proved. For example, in consent manager, let's imagine this is going to be a software. We are going to have a mobile application, right? So the mobile application part of the terms and condition when you're trying to utilize the consent manager service, so you are going to give those powers vested by the law to the consent management. It is more like a contract of a service if I look at it. Okay, so this is going to be a service, and the service is going to be binded by a contract, and the contract will enable you data subject to exercise this via consent manager. Okay, so I want to move the nominee versus the consent manager because consent manager, I see this as a service, and the reason I brought the concept of revenue model is I foresee there could be a revenue model attached to it at some point of time through some way, right? So which means it's more like a service, and the service is going to be validated by the terms and conditions you engage, and you allow them to raise those requests, right? And second part, if I don't use a consent manager as my agent, I can also appoint someone else as an agent, right? So this can happen. For example, NGO can act as a nominee representing the people who are maybe who are not educated and they are not aware of their rights. NGO can definitely act on their behalf, and this can be given in terms of a power of access. This could be a consent validation. Again, this is a consent provided for them to act on their behalf, and this can very well be validated by a letter signed by them, maybe in a specific government instrument. But the questions are rightly valid in terms of what is a valid mechanism to transfer the nomination, correct? So long way to go in terms of getting those answers as well, because I don't think this is going to come up in the first version of the final rules. This could come from the guidance on these areas. And trust me, GDPR had this EDPP guidelines, which are probably invoked from the existing guidelines that exist in the previous versions of the law. We have lot of guidance required in the Indian law also to be provided. So this could be one of the guidance which I expect them to clarify what exactly is the mechanism to validate the nomination part, right? So very good question, Saurabh, but we don't have answers for those. Yeah, thank you for that.
Maybe I'll write it to the government then.
Absolutely, we all of us have a very important role in this, right? So I'll go with Joyce. Joyce, you had a question. Joyce, you're there. I'll go.
Hi, can you hear me?
Yes, Joyce, go ahead.
Hi, Jay. Jay, one of the things related to the consent manager, if it is a application or a tool, right, that is going to behave or be a consent manager for an individual, then in that case, all data controllers will have to have some kind of an integration with that tool, and which means that if there are going to be multiple tools that is going to come up and behave like a consent manager, think about the amount of APIs, or I mean, I don't know, I mean, I'm just fathomly thinking about the implementation that in India we will have to do. All organizations are going to go crazy trying to manage consent.
Yeah, actually, two parts to
Secondly,
it. Yeah, so the first part you said, na, not everyone can become a consent manager. There will be limitations on that. Okay, so there is a qualification criteria for becoming a concern manager. But the second part, what you said, once you become a concern manager, it is your headache to ensure the integration with all the respective solutions, right? So just like a privacy tool will have multiple connectors with all the existing SaaS solutions, right? Imagine something like that. You need to come up with all the integration with the existing organizations, and this is going to be something which government should facilitate, like a UPI interface, correct? So how
correct.
UPI interface become a backbone for all the financial organizations to utilize on this. But this is not
Mm,
owned by private organizations, correct? So I am expecting something like that. If you leave the backbone to private players, it's going to be a mess, like you said. Okay. But if
correct.
it's going to backbone owned by the government, but just the last mile integration will be with the concern manager. This is what I foresee. Okay.
Okay. The second part of my question was around, I do foresee, or I see that consent managers could potentially then start misusing the data.
Of course.
And that risk is so high because
Correct.
the kind of population that we have in India, how much do people understand privacy? What are they signing up for? And
Absolutely.
if these consent managers are then going to go and sell the data or do what they do with that data, God bless these people who are going to become, who are going to give that kind of a consent or
Yeah.
approval to somebody to become a consent manager. So those are the two things which I feel is grossly
Any-
worrisome from a consent manager perspective in the
Yeah.
DPDP Act.
Yes, Joyce. Absolutely echo your thoughts. So in information security, we call the single point of failure. This is one of the case of single point of failure, right? So if it has a breach, for let's forget about intentional disclosure. If it is a breach also, it's gonna be having a very big impact on the trust of the people to use a concern manager going forward, right? It's a very sensitive topic. Let's hope that something comes out of it in a good way, right? So, Sarika, you have question on concern manager. I see also hands from Jivita. So I want to
Yeah,
quickly cover this. Trust me, there are more interesting topics. We are already almost an hour. So I want to quickly run
just
through this and come to
just
the yes, Sarika. Yeah,
yeah.
go
Hi,
ahead.
Jay. I won't take much time. Just
Yeah,
one curious question I had. So till the time we don't have consent managers in place, till that time, who will manage the consent? And that also brings me to the question that when is the law actually getting enacted, and what will be the transition period?
If I know that, I'll be making a lot of money, Sarika, today. If I know the exact enforcement date.
So,
That's
initially this when this rule came out, the rule book came out. So, I thought it's time that the law is getting enacted, but
yeah,
gradually realized it's not enacted till now.
that's
So
right.
the question is, we are still there is no clarity right now. The when the law is expected to be enacted.
Yeah. So I think when the final rules comes out, we will see information on the enforcement date. That's for sure. So that is what is being told. So we are looking forward to it. And until the consent manager comes live, individuals will have to take care of their consent in the respective fiduciaries. So that's how it
That
goes.
means, okay, the fiduciaries themselves will have to, have a okay
Yes,
setup. Okay,
that's what
thank
I'm.
you.
Yeah. Jeevita,
Yes,
Jeevita.
hi Jay. I just wanted to add on to this concern manager eligibility, while the other participant was also worried about who will be, taking the role of this concern managers. So I think the act provides the criteria of, to be met, right? There will be technical, operational, financial requirements, that has to be, that will be kept as an eligibility criteria to act as a concern manager. And further, the data protection board, they have the discretion to approve these consent managers. So it cannot be any kith and kin who can act as a consent manager, right? You can correct me if I'm
Absolutely.
wrong.
Absolutely, you're right. Anyone cannot become concern manager. They have financial criteria, financial stability, your trustworthiness in the society. There's going to be a lot of criteria that's going to be very keenly evaluated. And trust me, they are going to be subjected to more rigorous audit, okay,
Yes,
before they have been formally approved. So that is all there. That is all there. That government is very going to be very selective, at least in the initial stages. They are not going to allow private players easily into this concern manager's scheme of things, because trust me, one concern manager breach is sufficient to kill the entire trust, isn't it? So
right.
that is the reason they will be very, very selective in terms of giving this initially. And that is another reason what I felt is that it's going to take some time, right? So valid thoughts, clarifying that not everyone can become a concern manager, but everyone has they may try to become in terms of applying if they meet the criteria, but it's again, even just we meeting criteria may not be enough. The government will be very choosy about in terms of appointing them. Yeah, thank you so much. I'm just
Thank you.
jumping to thank you. I'm just jumping to the next slide in terms of the security safeguards. Okay, so I have called out in terms of the strength and weaknesses here. If you see the strength, the law has actually gone out to specify some of the technical and organizational measures, like mentioning about encryption, masking, monitoring of the personal data, logging and detecting unauthorized access, incident management. So I am actually quite happy with this, because in many data privacy laws, directly in the laws, they don't call out the technical organizational measures. It is maybe required in an Indian environment, because if you leave entire judgment to the organization, they will always debate about the security budget, and they never get anything concrete implemented to protect the personal data, right? So with these indication, I would say all the security managers, CISOs who are part of this forum, you can demand this to your organization to look at it. The law itself is given some specific elements to protect personal data, and that means we cannot go anything below this, correct? So you can go over and above this, but anything below this is going to be questioned, because it is also indicating something. You need to look at these things, right? So I'm just gonna highlight that for you to look at it whenever you're implementing your data privacy program, because the rules have specified some of the technical organization measures. That's good part of it, right? The second part which I'm gonna look at it is from the all the controllers in Indian law language. The fiduciaries need to have a mandatory contractual obligation with the processors, right? So if we are not having a data processing agreement, high time. Don't wait for the rules enforcement. This might be requiring 6 months, 1 year period for a large organization like a bank, insurance companies, or any B2C organizations. It's going to take a long time. So start trying to bring up your requirements as data processing agreement. Why I'm bringing this point here specifically? Because you see the Indian law has a catch in terms of not calling out any specific obligation on the data processes. And this is a very important pain point for all the fiduciaries. And trust me, if you are a fiduciary taking the services of a large software as a service platform, and unfortunately you are not able to call out the required technical and organizational measures, and if there is a data breach at the processor end, who's gonna bear this entire brunt of the law? It's gonna be the fiduciary. Unfortunately, this is how it reads right now. Okay, so which means there is no independent obligation on the processors in terms of technical and organizational measures. If I had to translate this, if you miss out, okay, calling out your technical and organizational measures, part of your data processing agreement, okay, this is going to be on you as a fiduciary. Okay, so very, very critical. Be as prescriptive as possible for your technical and organizational measures, the important requirements of your data processing agreement. But this is going to come with its own challenges. The first important challenge is the cloud service platforms, the software as a service platforms, which are processors of your personal data. They may not allow you to fine tune your data processing agreement. And this is where you need to red flag this. This may have worked with GDPR, but in the Indian context, you need to ensure that the obligation of a data breach, okay, is gonna be on the processor. Okay, this has to be fine-tuned to the Indian law. If the processor says that I'm not gonna put it in my data processing agreement, and trust me, you should not engage with the data processor. Okay, I'm making a very important statement. It could be any big player. If they are allowing you to only sign a international data processing agreement template, which usually is different from the Indian version. The reason is there is no explicit processor obligation for technical and organizational measures, and big organization can misuse this, right? And that is the reason I want to make it very, very clear that your data processing agreement should have this explicit requirement focused on your contracts. Okay, and if you cannot do this, you are gonna have a high risk flagging into your organization, and you need to pray that there is going to be a data breach on your processing, right? So I know there's going to be a lot of questions. This is going to create a sort of market uncertainty also. The reason is this might actually kill the small players. The reason is the fiduciaries going forward might target the processors who only provide, who are the only ones who have a cyber risk insurance, okay, who will be able to bear the damages if at all there is a data breach, correct? So this can create that market uncertainty for small processors because they may not have such kind of liability insurance to cover up the damages, correct? This is one of the points which I definitely feel where the processors might have tough time, and the big processors will enjoy this kind of loophole because they don't have a direct obligation. If the fiduciary fails to call out these obligations, they can usually defend it saying that we were not mandated to have these controls, right? So this makes a very challenging part for the fiduciaries. Ensure those requirements are called out explicitly in your data processing agreement. All right,
Yeah,
so
we would like to add over to that in case there's a discussion. Really good question from Ganesh, and this makes a sense that if the third party is handling the data and the loss is belong by the third party negligence, how we are understanding about this?
unfortunately, the law is saying that everything is borne by the fiduciary because the third party was engaged See, you
That's
need to
true.
look at the word third party in two ways. Okay. The first interpretation is the law is making you responsible for the breach happening at the processor and the subprocessor. Okay. But the law is not gonna say the same language for third parties where you make them an independent control, right? So which is independent fiduciaries. So the point is, the moment another fiduciary is involved, then their liabilities will not come into you. But if it is a case of processor and subprocessor who are acting on your instruction, so in that case, definitely the liability is going to be you. You cannot shy away saying that it is a breach happening at a processor end and we are not responsible for this. This is not going to be accepted. If you look at the law statement, it clearly says the fiduciary are responsible to engage with those processor who are going to protect the personal data, right? So the vendor due diligence, the contracting requirements, the vendor risk management, as I keep saying during all my training session, are going to have a huge a task to be played by all of us, right? Especially in the Indian environment. All right.
I think that really answers the questions of Ganesh.
Yeah. So I see a question from Jivita. Yes, Jivita, quickly, let's cover this topic.
Yes. So I am looking at the way how we can overcome this challenge. So I understand whatever at the end of the day liability is on the data fiduciary. Can we overcome this liability by obviously we will have a provision wherein we'll have this compensation for all the losses that's occurred because of the breach from the processor. So that is the only way I look at to overcome this challenge. Is there any other way out, or would this be a right way? And is there a possibility of joint liability that can be brought in?
Very valid points. I think two options are there. One, the limitation of liability clause, okay, which is indemnifying yourself for the breach, which is solely originating at a processor or sub-processor end. The controller, the fiduciary can exempt themselves or allow themselves to be not sued for these kind of damages or the penalties from the data protection board. And second is it's going to be a transactional breach, so they might look for the processes which provides them the cushion of cyber risk insurance as well, right? These are the two ways which I think the industry is going to move forward, looking in terms of a strong indemnification of the fiduciaries and putting the liability on the processor. And trust me, you cannot put a liability of a breach originating at a fiduciary to the processor. That's not possible. Even if you try to do that, it's not gonna work. Okay, so we are only speaking about the breaches originating at a processor and the sub-processor end. Okay, for those breaches, the indemnification clauses and the cyber risk insurance are the two way outs in terms of limiting the damages for the fiduciaries. All right.
Can there be a joint liability, Jay?
Joint liability is not possible, because why would I take a penalty for something happening at a processor end? Or a processor, why they will take a liability that's happening at a controller? That's not going to happen. No one is going to share your tough time in terms of penalty. Okay.
Okay, at the max, we can, have an indemnity and a limitation of liability provision to carve out to what extent we can be liable for.
Absolutely. Absolutely. Yeah.
Thanks.
The Shilpa asks, is there a concept of joint fiduciary? No, Shilpa, there is no concept of joint fiduciary in the law. In fact, independent fiduciary is also not called out. Clearly, it's also slightly a gray area in the law right now. Okay. So I see a question from Saurabh. Saurabh, you have a question?
Jay, regarding this joint fiduciary only, there's a section in the DPDP Act, Section 8, Clause 3, subsection B, which talks about another data fiduciary, and that's the only mention of another data fiduciary that I can find in the Act, unlike GDPR, which calls out for joint fiduciary. So, don't we have this concept in DPDPA? calling out from this particular section 8
If
3B,
you read out the exact statement, okay, so
right?
it
I can.
is yeah, it is more like fiduciary to fiduciary collaboration. Okay,
Right.
so that can reflect in terms of the two independent data fiduciary working together. It doesn't make a joint fiduciary concept. See, joint fiduciary or joint controller concept is different from two independent controllers working together. Correct. So we should not
Okay.
interpret that as a joint controllership. See, joint controllership, again, even in GDPR, it is not a shared liability. Okay, so how it is usually seen by the authorities and the data subject, it's more of an internal arrangement between both these controllers, and in front of the law, each
Right.
of them are liable for their share of damage. Okay, so that is how it is gonna pan out in the Indian scenario as well. So this joint controllership is more of an internal arrangement from any lens of data privacy laws. Okay, so in the Indian law also it's going to work out that way. Okay, the only challenge is that sometimes the ebbs and flows of relationship between different fiduciaries requires a term of joint fiduciary. Okay, so that makes it more easier to give the various stakeholdership. But when you don't have it, then we have to play out only between these two terms: controller, processor, controller, and independent controller. Am I right? So that's the only challenge I feel. Okay, so that is something which we need to take care. I think Saurabh is calling out there is a provision of who alone in conjunction with other fiduciary. Is there a definition? Okay, so maybe there is a interpretation possible, but what happens in terms of joint controllership maybe is not called out. But I think Saurabh is saying that there is a provision. Okay, but maybe it's not called out as like we see in GDPR. All right. Manoj, thanks Saurabh for that. Manoj.
Yeah, hi. I have written my question over there. So the question is
Uh,
that in case of violation,
hmm.
so how this will be handled?
In case of violation, it's gonna be looked at from who caused this violation. Okay,
Will
is
there
it
be
gonna be?
negotiations between the parties, or will it
It
go
is.
be settled by arbitration? How they will be handling it? Will
It
there
will
be
be
just a
usually,
straightforward
yeah,
penalty?
correct. Usually the penalties originate with the fiduciaries. The fiduciary will pass on the damage if it is solely originating from a processor. So this is how it works. Okay. So usually the data protection board is going to be involved in this investigation, and they will determine if it is a complete breach which has nothing to do with the fiduciary, then the penalties and everything is going to be given to the processor. Okay. So arbitration will come only when there is a dispute between both the parties. One party is saying that I am not liable and this is being forced.
Definitely that may arise. Yeah, that
That may
definitely one will
arise.
claim. Yeah,
That if you are saying arbitration word will be done by the data protection board. They don't do arbitration, they slap penalties and they say we have done this audit or investigation, and they will say that this is the party which is responsible for the breach. Okay.
yeah, but every situation is challengeable. So during that, because one has to safeguard its own
Yes, yes,
organization,
yes.
even in
Yeah,
case of we have made a violation. So in
correct.
that case, how we will be handling it? What will be the process, or
No, the point
parties?
is, for example, processor is being forced to take a penalty. They are not going to accept it, correct? They will
Correct.
be putting forth this to the data protection board. Any inquiry of a data breach is going to be investigated by the data protection board. So the
Correct.
data protection board will take the final decision. Okay.
Hmm.
So that decision will be again arbitrated if it is being
Correct.
challenged against the appellate tribunal. Correct. Even against appellate tribunal, you are not comfortable with the decision, you can finally move to the court. This is the channel of arbitration that is going to be defined in the Indian law.
Because one may ask for a larger amount of damages, and other may say that it's a petty
Absolutely.
one. So where
Absolutely.
there it comes the arbitration or negotiation, there can be negotiations. Can negotiation play a part in it?
You will not be allowed to call for your penalty. It's a decision given by the authorities. You can dispute this. And finally, the authorities may look at the merit of the case. They can lower the penalty. And usually the authorities don't do it. The next level of arbitration might happen with the court, or it might happen at the appellate tribunal. That is the only way to handle it. Okay.
Are our lawyers well acquainted with this to handle this situation now upcoming? Because they
Might be.
might
We have
not
to.
be that technical.
Yeah. So we have to wait and see on that, Manoj, how this is going to pan out. As far as I think, it's going to be a call within the bounds of only the authorities. Okay.
Sure.
So
Thank you.
thank you. Yeah, I think we are left with only 15 minutes.
Only
I
one
need to.
small question.
Yes. Yeah, go ahead.
As per Rule 12 of the DPDP Rules, recently drafted, there is a requirement for obligation that a fiduciary to file annual return, as well as do the get it done by independent auditor. Independent auditor. Are you hearing?
Magesh, your voice is very feeble. I only heard that there has to be an independent
Are you
auditor
hearing?
appointed for the significant data fiduciary.
As per Rule 12 of the DPDP Act, there is a requirement for the Rule 12 of the DPDP Act. There is a requirement for the judiciaries to get annual filing and get the audit done by an independent auditor.
Correct.
As per the requirement, what is the definition of independent auditor under the DPDP Act?
Right now, it's not defined. It's something. If you ask me from my experience, they cannot be internal auditor. It has to be a third party auditor. And if you ask me what is the qualification,
Is it set in certified auditor?
Correct. That's what I'm coming to. That the qualification criteria for independent auditor is not defined, and not necessary it has to be a certain empanel auditor. See, this audit is different from certain empanel scope. Okay, I foresee there could be a new certain kind of scope that could be coming for the DPDP Act as well. Okay, so what I see here is there is a provision for certain empanel auditors can do this. Also, we might see some extra obligation called out for data audit specifically for DPDP Act. This is a space we need to closely watch out in terms of how this is going to be defined. Right now, the qualification criteria is not defined. All right.
Also,
Okay.
regarding children's
I'm going to cover that in the next
personal
slide.
data for guardians, and
Yeah.
also for the employees. Employees, particularly, the offer is withdrawn after getting the background checking and everything, getting all information from the employees, from the onboarding employees. After that, offer is withdrawn for some reason. In that case, what is the legacy data of the employees, the personal data, and what is the rule for that? How they are going to deal with those data from the employees, ex-employees and existing employees during or after exit?
Excellent question, because the law has given a sort of a loophole for employment purposes. Okay, that's a very broad legitimate use. It says the personal data can be used for employment purposes. So pre-onboarding data can fall under employment purposes. Unfortunately, it has not called out any further specific obligations on that part. Okay, leaving a great deal of ambiguity, as you called out. A person who is withdrawn from the interview process or rejected the offer letter, what happens to their data? It's not based on consent, right? So it's going to be part of a legitimate use, which is employment purposes. How they are going to be addressed? What happens to their rights? That's a big question mark. Right now, we don't have an answer for that.
That is one part. Second part is existing employees after or retrenchment or after exit on legally. What is how they are going to deal with the data of those employees until retention? How many years?
See, retention is going to be, yeah.
No, that is okay. For those employees' data, to what extent they can retain those data of personal salaries and other things. Even for income tax purpose, they may call for information from the employers. So in that case, how they are going to deal with those data? That's another question.
Correct. So those data is going to be kept for as per the legal regulatory requirements. Usually it is 7 years, 8 years period is the timeline which I understand usually taken care.
7 years, but 3 years maybe.
3 years for, see, some sectors will mandate a 7-year period.
As per the e-commerce sites and other things. Okay. There are certain sectors they have mentioned for different
Correct.
periods
So
for different sectors.
correct, that is true, and that is the way it
Yeah.
should be as well, because there cannot be a common retention period for all the industry. So it is our obligation to maintain and as per the regulatory requirements and legal requirements, right? So the answer is how long we maintain. The retention period clarity is not called out yet. Okay. So that is something we still don't have an answer. I'm going to quickly cover a couple of slides. I know you have all interesting questions. Just give me a
One
couple
more,
of,
simply I put this question and leave it. What is the basis for identifying whitelist and blacklist for the
I'll come,
DPDP for as well as in data transfer is concerned, international data transfer? So can
sure,
I
my
keep the data outside India and the cloud somewhere as per the whitelist? So what is the risk on that? They have to do the deal. You accept that? Will you accept that?
I will not accept. Why would I accept? I neither like it as well. Okay. Because I don't have the pen, I can't write it right now. I hopefully we will make our
Then what is the
voices.
logic behind notifying whitelist and blacklist?
We'll come to that, sir. It's not
Okay,
yet
okay,
live. So
okay.
we have to wait for it. Okay.
Okay, I
So
will proceed. Okay.
yes, thank you so much. So I'm going to quickly cover a couple of slides in terms of my favorite topics, which is the data breach. Trust me, one of the most ambiguous part which has been called out is the data breach notification part. And the reason for that is they have said two conflicting notification part. One, for a data subject, they have said immediate notification. Okay, and for the data protection board, they have said 72 hours. Now, this is exactly opposite how it works in GDPR and other data privacy laws. Usually, you don't want to inform data subjects when you're not certain about the breach. Second thing, a data subject notification is something, a very important decision for the organization. It's almost like a make or break decision. The organization may disappear out of the market in next 12 months or maybe in 2 years after the breach, right? In these kind of situations, usually you need a time to identify the impact of the breach, identify the reporting part, how to mitigate the breach, how do I sort of take control of the breach, how do I manage the breach reporting part to the supervisory authorities, or in the Indian case, the data protection board. All these are some important decisions. So we usually call this as a breach impact assessment, right? So a lot of critical analysis, some important measures to be taken in a window of period. And that window of period is rightly given as 72 hours. But unfortunately, for the data subjects, it is said immediately. Now, what happens is, if there is a breach, you need to inform the data subject first. But when I say to a data subject that there is a data breach, they're going to ask me, what is the data breach? How I am impacted? What kind of attributes are being impacted? So probably I will not have answers for all these questions. This is only going to create more chaos for my customers, correct? So what is missing right now is a graded notification. A graded notification in terms of calling out that a risk and high risk in terms of GDPR. Or simply speaking, it should be a risk-based approach of notification, correct? So you need to align some parameter here, that what will quantify a notification criteria for a data subject. I understand that the threshold of informing a data subject immediately makes sense, okay, because it could be a very sensitive stuff which is getting breached. It could be a matter of someone's personal data involving financial information is breached. So they need to be immediately informed about this. That makes sense. But that is a specific use case. But there could be n number of use cases like that. If you do not have a graded approach of qualifying what constitutes a breach which will fit into this bucket of immediate notification, it's only going to create more chaos, and ultimately organization will not take this seriously. Okay, this is one of the very important point that I would like to call out. And another missing area is, usually sensitive personal data is something which is part of this risk-based approach, correct? So that will call out the specific requirements, especially your biometric data, your data related to your race, right? In terms of ethnic origin, your DNA, or all these aspects will have some very big impact on the people, isn't it? So these data should have some specific information to be called out part of the graded notification, right? So these informations are definitely missing right now. Okay. And I'm gonna pause for 5 minutes after I complete the couple of slides. Okay, so the next slide is, a lot of people ask me this question about your time period of data retention and children consent. Okay, right now, unfortunately, in the law, if you see that there were three industries called out part of the significant data fiduciary, which is the e-commerce, online gaming, and social media platforms. There is one important question which is still not answered is, are they the only three significant data fiduciary? No, that cannot be the answer. And also, why only coming up with the retention period for these sectors? This is creating further ambiguity for others. How do they interpret these requirements? Correct. And also 42 hours user notification for when there is no sort of contact between the data subject and there is a dormant period of 3 years. You just need to inform them 48 hours before deleting the data. What if I'm out of station for those 48 hours? What if I'm not accessible to that email communication when I'm not there? So this can also be a case of concern. Why not give it 1 month before the data deletion part? So I would say a 48 hours window could be too short, right? In case a person is not available. This is something which I want to call out as well. The consent for children or person with disability, a very big factor in the Indian law. Right now, there are a lot of questions around this. One is verifiable parent consent. There has to be a mechanism developed by the government to facilitate this. Otherwise, this is again going to have a lot of ambiguities. Two areas that can be easily misused. One, if you leave the fiduciaries to collect the age, this is only going against the very principle of protecting the children's. Okay, that's the first part. The second is, if you don't collect the age, then age graded services cannot work effectively. This is again going to be failure of not sort of ring fencing these kind of services only to the limited age groups. Now, the third part is, if you have a centralized mechanism, okay, which allows a tokenization concept, like what is mentioned by the rule as well, which allows a minimum data. I came up with an hypothetical concept. For example, any individual who is less than 18 years old who want to seek a service on internet, maybe they can be allowed if they present their masked Aadhaar card number, and the masked Aadhaar card number can be used to get an authentication, a centralized authentication of yes and no. And this ensures the identity of the person is preserved. At the same time, this will also allow sensitive graded services only for the people who are above 18 years old. Am I right? So I'm just suggesting this is something which can definitely work. I think the government and many other regulatory authorities are working something on this. The challenge right now I'm seeing is how many people are going to be aware of this digital locker concept, and how many of them are going to have masked Aadhaar, right? These questions are going to be very tough, right? If we are going to have an effective children consent, we need to have effective verifiable mechanism of parents and guardian. The definition of guardian itself is going to be challenged, right? So you need to look at guardianship is something is not only defined by the Indian DPDP Act. Guardianship is allowed under different industry norms as well, right? So guardianship could be people with disabilities. What ascertains guardianship? If you say you have to go to a court order to get a guardianship, just imagine how many people are gonna actually do this on real time, isn't it? So there's going to be a lot of questions raised on these aspects, right? So that's something which I personally feel verifiable consent, the definition of guardianship, and the integration of digital locker or any other mechanism for central child consent has to be robust, and it should not leave the choices for the fiduciaries to collect those data, right? So, and also the age determination factor, unfortunately, in India is kept as 18. I still feel this can be lowered, maybe 16. Okay, because that citizenship and the age, a lot of things, we are moving much rapid phase. I believe 18 is something is when you allow an individual to take the choices on permission for taking an online service. I just feel it's it's curtailing their wings on these concepts. Okay, so a balanced approach definitely needs to be taken up. Okay, so there are few general observations. I'm gonna quickly call it out. Okay, one, in terms of data subject rights, the rights which are called out in the Indian law versus some global data privacy law like GDPR, there are rights like data portability, right to objection, right to restrictions are missing. That's something which I definitely feel, especially data portability. Many people may not know the effectiveness of such a right, which allows the data to be transported between different cloud service provider or software as a service provider, right? And also this objection of right to object for legitimate interest, as well as your public interest, was a very effective challenge response mechanism. So here those options are missing. And I think your cross-border data transfer, we have discussed this in detail. Right now, it's more of a whitelist backlist concept in terms of not having any risk-based approach like a transfer impact mechanism. These things are completely absent, right? So that I would say as a very big loophole for organization to just keep sending the data outside India, and they might just follow the whitelisting concept. I feel like standard contractual clauses or in terms of any other mechanisms, you need to have a risk-based approach that will ensure the controls are enforced to protect the data whenever the data goes out. The liability should be borne on the data exporter. Unless we do this, then we can never say that the sovereignty of Indian personal data is going to be strictly taken care like the way we see GDPR or any other law, right? So that's something which I definitely see as a limitation, right? Automated decision making, I've told this earlier that this is something which is currently lacking in terms of controlling the AI decision making. And if it is an AI decision making, you're not going to call it out. AI is not a person. AI is taking decisions for people. And this is going to have very big impact on 2025, 26, right? Just imagine before the enforcement comes, already people would have been victim, right? So I definitely foresee changes related to automated decision making to be called out part of transparency, and allowing data subject to challenge those automated decision making is something which I feel should be brought, especially if it's handling personal data, right? So the education institutions are completely sort of exempted, okay, part of the your consent and other requirements. And don't the education institutions also do marketing activities? Are they not? Education institution is a very broad term. What about those this CAT tuition centers or this medical entrance tuition centers? So many institutions can also fall into the category of educational institutions, isn't it? And they are doing aggressive marketing with personal data, isn't it? And they might enjoy this loophole because they will fall under this exemption. And they are doing extensive marketing activity than legitimate purpose of processing data, isn't it? So this is something which I feel they need to clarify who exactly might come under the education institutions. In terms of principles, few of them are lagging in terms of data minimization and privacy by design and default. This can be the guiding principle of privacy program implementation for the organization. And the very definition of significant data fiduciary is missing. Okay. So these are the some of the important areas. Now I can definitely allow you to ask question. I'm going to be available for next half an hour or 1 hour as well. Whenever you want to complete, I'm there. I still see at least 93 participants are there even after the scheduled time. I'm extremely
Right.
sorry because we took more time, but I'm there. As you know, all of your questions will be answered, even it takes another half an hour. Okay. All right. Let's go for the questions. I see two hands raised. Mr. Subaraju.
Yeah. The certain says 6 hours for the data breach reporting, and DPDP says that 72 hours for data breach reporting. So
Yeah.
you mean to say that I mean, in your view, is the DPDP supersedes 13?
No, your regulatory requirement is shorter than your DPDP Act, so you need to fulfill both obligations. You cannot say the law says 72 hours. That is only covering personal data, but certain is covering all type of data, not just personal data. Am I right? So in that case, the certain requirement is different and is only for regulated specific sectors as well. Correct? So in that case, certain requirement will still stay, and the Indian DPDP Act is only covering the personal data, right? So both these requirements will still stay. I don't think this is going to change the certain notification window. Okay.
So another question, follow-up question. If there is a case, for example, if there is a data privacy breach,
Hmm.
so we need to inform certain within 6 hours, and we can take 72 hours to report DPDP.
Exactly. So if it is a personal data involved, you need to inform certain within 6 hours, and you will have 72 hours to inform the data protection board with your breach impact assessment. This is how it works.
Mhm. Okay, I understood.
Okay. All
Yeah,
right.
and the other thing, I have a few more if you don't mind. So when I started in the beginning, we were talking about the the SaaS applications or e-commerce application. Someone is logging in and signing all the privacy agreement, blah blah blah, and getting into the system. After one transaction, if he says, "I want to withdraw my consent," or "I want to delete my erase my all the data," so this kind of request comes frequently to the e-commerce, like global e-commerce site. How they are going to handle this?
they have to handle it.
Even yeah.
They have to handle it.
No,
It is
how?
consent.
See.
The consent is their permission. Okay. If consent is withdrawn, then probably they have to withdraw their request as well. See, I know where you're coming from. The challenge is contract-based processing is more effective for e-commerce sites. Correct? So it's more of a
Mhm.
service. And for a service, a contractual binding will be more effective for the organization. So that is where a smart company will not move into a consent based mechanism, rather will use a legitimate use, which is your voluntary processing of data.
Yeah. So even if I sign, say for example, I'm signed up with some kind of the healthcare portal in India, which is built in India, which is serving across the Indian origin. After one transaction, if I say that I want to withdraw all the details from the your portal, so like it is something multiple applications are coming like this. How an organization is can handle this kind of request, because this is practically it's not doable at the immediate nature. So do they have any the time gap between the request and the response, that just it has been removed and then communicated back to the data subject?
See, Subraj, you need to understand two things here. One, how did you associate with the data subject? What was the lawful basis? If it is based on consent, then I think you're going to short your own feet with the kind of mechanism like that. Okay. The second thing is that if it is consent based, if they withdraw on consent, you don't have any other alternative. If you
Hmm.
feel that it's going to be a legitimate use, depend on the legitimate use that allows you a larger window, especially if it's a legitimate use, we will not be forced to delete the data because it could be a binding requirement for you to retain the data to fulfill the service, or you might have some legal regulatory requirement to still retain the data. Am I right? So imagine it's a
Yes.
health sector. Health sector will have a specific regulatory requirement to retain the data. So that will supersede the data subject requirement to delete the data. So you need to keep this in mind. Data subject rights are notional. It's not like it will supersede every single factor. The law, the regulatory requirements, okay, will also supersede a individual's rights. Okay. So
Okay.
that means you need to balance it in terms of situations. If it's a purely consent based, as I told you, you need to be really careful because the law provisions them to reverse the consent. Okay. But if you have a legal regulatory requirement backing to retain the data, you don't need to delete the data. As simple as that.
One last question. When we talk about the data transfers, because most of the MNCs, global MNCs, they hold single ERP system, where they serve from the single ERP on the cloud to multiple countries and multiple regions. So in this scenario, if some blacklisted country or whitelisted country which is coming into the existence, which is displayed or by the board, so in that case, the data localization may not be possible, right?
Data localization is something which we have to see, wait and watch. When I saw the rules, it's going to be mandated to certain type of data for significant data fiduciary. Okay. So only to specific type of attributes and only tying back to the significant data fiduciary. This is only the provisional option given in the law. Okay. And that whitelist and blacklist, we need more clarity from the government, how they are going to implement it on ground to manage the risk of data transfers and how they are going to ensure the sovereignty of data is going to be taken care. All these are a lot of questions which are there. So
Mm-hmm.
don't have answers yet. All right.
Mm-hmm. Mm-hmm.
So
Okay, okay.
thank you. Thank you for excellent questions.
Yeah,
I'll
yeah, thank you.
Jay,
cover.
just if
Yeah,
if I could just chime in,
yeah.
for some of the questions that were just asked, in my experience of working in privacy over a period of time, even if somebody makes a request to delete the data or withdraw the consent, if the organization has a legitimate purpose or a reason why they should hold that data, they can go back to the sectoral laws can supersede. So DPDP Act will not necessarily supersede the sectoral law. Like for example, I'll give you an example that, like for example, RBI in the banking sector. Now, if the banking sector says that you have to keep the transactional data for 10 years from the time, and that will be for anti money laundering or various other reasons that a bank has to keep the data. Even if I as a customer will go to a bank and say delete my data, at this very point itself I can say no, I will delete it, and I will delete after the retention period. So
Correct.
this is how organizations in Europe, in US have been working on deletion requests. A simple example to add to it is like, if say for it, there is a legal case that is going on, there is a litigation that is going on, then in that case that data will not be deleted by the organization. They will say no, we will hold this data because of for legal purposes, like how Jay said. So therefore DPDP Act does not necessarily say that I have withdrawn my consent, you have to delete all my data right now. The organizations will have a say to go back and say no, we will not delete your data, and this is the reason why. And if the reason
Absolutely.
is valid, the data subject cannot say anything about it.
So yeah,
Very
so
valid point.
one
What
point
you
here
said
on the
is,
same
yeah,
one point on the same thing. If
yeah.
this is the case, the data retention period ought to be published on the along with the privacy policy.
See,
So
retention period will add to actually look at various factors. Like what Joyce said, there are legal regulatory requirements. Sometimes it is something will start after the business purpose gets completed, right? So the retention period may not be called out in every situation. Sometimes just the criteria just needs to be called out. And like the way Joyce said earlier, data subject rights are notional. It cannot be absolute in every situation. I am only apprehensive about consent based processing. Okay. So if you choose consent based processing, the chances you need to be on your toes, because the legal regulatory requirements, if at all was there, why did you choose a consent based processing is going to be my important question in the first place. Okay. Isn't it, Joyce? If you have a legal regulatory backing for the data to be processed, why should you need to choose a
yeah,
consent
you
based?
should not use a consent based processing in that case.
Isn't it? So that
Yeah,
those are some of the tricky part which comes as an operational challenge for the organization to need to understand consent is not the end of the world. Okay,
correct.
so there are other means of processing the data, and you need to explore those options on only where places where you need to give the absolute control to the data subject. I feel that is the channels where you rely on consent. Okay. So be careful about choosing the right lawful basis. That's my humble request. All right. Thank you, Joyce. Excellent viewpoints. I'll just quickly move to Saurav Padi. Hi, Saurav.
Hi, Jay.
Hi,
Thank you for
hi,
the
Jay.
session.
Okay.
Too many
So
Saurav we have. Yes, Saurav. I'll go
Sorry,
with
sorry.
Saurav. Yeah, Saurav Padi.
yeah,
Go ahead.
so
Yeah.
just had a question. I think you also raised the same concerns which I have. Fundamentally, in case of minor consent and a verifiable consent, how do you connect the dot between a guardian and verifying the age? And because today, if you see, Aadhaar even doesn't mention about your parents, because that's a new style of new format of Aadhaar that comes with other parents' name are missing. And how do you connect those dots and verify that's the person who is the guardian?
Yeah. As we speak, there are some discussions happening. The government is actually very keen in creating a central verification mechanism. Okay. As far as I know, that's what is happening. Hopefully, we will see that someone is going to find a solutions. Okay. So right now, there's a lot of challenges, but I definitely foresee and have hope that we will come up with some solution. That should be a centralized mechanism, and the backbone should be owned by the government. Okay, that is what I feel will be a most effective way. All right.
And
There is a process of, sorry to interrupt you.
go
There is
ahead.
a process of age gating and verifiable parent.
Mahesh, you need to be very loud, Mahesh. Your voice is very
Yeah,
feeble.
there
Yes.
is a process of age gating
Mm-hmm.
and verifiable children.
Mahesh, I have to skip the question, Mahesh. I'm really sorry because your voice is not audible. If you type your question, I can read it for you. For sure, I'll answer the
Yeah, I
question.
had
There
another
is
question.
a process of age gating
Uh-huh.
and it's verifiable from the respective authorized signatories for the those cards and other things. That should be a process. There is going to be a process for that.
Yes, there will be. There should be a process for
That
this.
is called age gating. That's why they
Yes,
mentioned. Yeah,
correct. That is
particularly
still
for age not completed 18 years, they have to get it verified.
exactly. That is what I said. It's yet to come, but it is being provisioned or being envisioned by the
But at the
government.
same time, we have to do the due diligence for the legality of the adult identification. That's very important.
That is what age gating is also indirectly referring to,
Yeah,
right?
yeah.
Only having the right people means you have to verify the legality of the age as well. That will happen in a more option which are less intrusive, not collecting the actual age, not collecting the actual name of the child. Okay, you should do it with the pseudonymous data. That is what I'm trying to do, address it here. All
But
right.
the rules do not specify any mandate for this data.
Early days, early days,
Yeah, to
early days.
verify the relationship or
Yeah,
the
yeah.
kinship
We will
between the child and
correct,
guardian.
correct.
Yeah,
Correct. It will come
rules
out.
do
It
not
will come
specify.
out. Yeah. But we have to raise these questions, right?
Another thing is that the periodic impact assessment for the privacy impact assessment, they have to do on periodical basis.
Hmm.
As you said earlier, not only at breach, but it should be on a periodical
Data
privacy
protection
impact
impact assessment.
assessment.
Yeah,
So
yeah,
how
yeah, yeah.
frequent it should be?
Unfortunately, if you see the laws, it is limited only to the significant data fiduciary right now. Okay, that itself is a flaw. You should not expect only the significant fiduciary is going to have a risk for data processing, isn't it? Even a normal fiduciary can have a high risk processing activity. I would say, irrespective of the law mandate, every fiduciary handling personal data should do a DPIA, and that is for any high risk processing activity. Okay, so that should be done on a need basis. There shouldn't be a periodicity. There should be a need basis.
That
What
is
you're
also another thing that
what you're referring
for a significant judiciary,
uh,
data judiciary, only DPO is requirement is there, whereas it is not required for other than the non-significant.
correct. That is what
Non-significant data judiciaries is not required, whereas only significant judiciaries DPO is required, whereas consent manager is required for all type of companies. What
correct.
is the logic behind this?
See, logic is higher risk, higher obligation. Consent is for everyone. Okay, that is the reason. So probably it should have been mandated. See, even for the fiduciaries, a point of contact has to be appointed. Just the DPO is not required. Okay. So doesn't excuse any organization from appointing a point of contact. That is very important.
But they are not also not defined what is significant data judiciary.
That is also
That
I
is to be
called.
discussed.
So what then deadline? How they are going to meet? within this short duration. They
We'll
have to
see.
start appointing DPOs, independent auditors, data auditors, then periodical assessment, periodical audit. They have to do all that tasks to be completed within the deadline. So it's a very Herculean task for these
Lot of
areas.
work, lot of work for us to do, sir.
Yeah. That's what.
Absolutely.
And,
Lot of job opportunities for everyone who attended the session as well, isn't it?
That's absolutely.
so are you willing to be a DPO?
Sir, I'm acting as a DPO for organizations already.
Super.
That's
Okay.
absolutely true.
Yeah.
So you
So
won't sleep at all.
right now I have a good sleep, sir. I'm waiting for the enforcement date. Then I'll take a call. I'll change my designation then.
No, they are notifying 3 to rule 3 to 15 and 21 to 21 and 22 immediately. There's
Yeah.
no till February 18th. So
Yeah.
other than this, it will be delayed maybe.
Correct, sir. Sir,
Important rules they are
it's
notifying in February.
it's becoming a dialogue, sir. A lot of people have raised their hands and they are patiently waiting. It's already
They given deadline 18th February.
No,
yeah.
just I've been part of multiple forums with Data Security Council of India and FDPPI.
Yeah.
Currently, I mean, all individuals as well as privacy professionals like us, organizations are allowed to first give feedback first on these guidelines that have come.
Absolutely. Absolutely.
And I mean, trust me, organizations are going to go back and say this is impossible to implement in these timelines, and
Yes.
the government is going to hear this out.
Yes.
There'll be a phased. What I hear right now is that there's going to be a phased implementation time. Even when
Sure.
you saw GDPR, CCPA, CPRA coming out, they had given organizations a year and more, and there was timelines given to this. So
Absolutely.
I think I am seeing that because of India and the kind of data that we have, this will span across 2 years or 3 years for full implementation. There will be partial implementations that will go on the road, on the way.
That's absolutely true. I mean, that's very nice. Joyita said about that.
Anand, if you leave, I know for sure my participants are gonna be there for another 1 hour as well. Okay,
No.
so because
We
I know they have so many questions to
we
discuss and
we
very
we they will for sure bring similar event for all of them, because the energy they pack is really amazing. I would love those who are comfortable just can pull up their cameras and just give a smile of cheer to Jayan. It will be very great to see. That
I
will be very
actually not
nice.
seen any of the participants in
Yeah,
my chat.
Saurabh is there. It's amazing. It's open for you all because this is an open discussion.
Again,
Let's give
this
a
is
high five to Jay.
this is a concern based. Okay, Anas, my participants are very sensitive on data privacy. Okay.
That's what we want to see here, only, na? That's what we want to see. The partiality, the transparency you want to become, or want to bring for the nation it starts from here only. From
Yeah.
when we get this confidence from the data privacy owners, the data privacy experts and strategists
Yeah.
to know and understand that they're very open to tell us that okay, if we can do, you guys also can do.
Yeah.
And that's how we wanted to get the confidence. Pretty nice. I mean, it's
Thank you.
late by 10 also. Some of them are joining from the India as well. This shows the
Yeah.
interest. The nation actually bringing the interest to these topics and these agendas. It's really amazing to see the confidence and the great energy they bring in terms of discussions. I don't think a law can be discussed in 45 minutes or 60 minutes. We'll try bringing such events every month by the time we get the final upbringing for that.
Sure. I think we'll definitely have a follow-up sessions on this. I feel the
Definitely.
energy and interest, we should not limit it to just a session. And as I always promise, we will have sessions where you can ask questions. Unfortunately, you could not ask your questions here. Just keep it yourself handy, and you can write to me if you are already part of my trainings before. You can always reach out to me, and we can come out with another session like this, and we'll be more than happy to address your queries as well. I'm excited like all of you to answer as well as get enlightened by your question as well, right? So fantastic interaction, I would say, right? So
Sorry,
yes.
I'll just barge in here. Just one feedback for the next session. So
Yeah.
currently, most of the people in the forum might echo. We are now like we are organizations looking on us to give the start the journey for the preparation of uh, DPDPA compliant. So what are the key 5 or 10 things that we should really focus on? For example, like one thing comes to my mind is that we should start looking at the contracts with our vendors to see whether we have a data processing kind of a liability being mentioned there, the breach thing that you mentioned. So that's one thing, because the contracts are annual, and the that's 1 year time we have for any even annual like a renewal contract. So that's one area that we should start looking at. So what are the key 5 or 10 things that we should start preparing as a first top priority in our preparation? That's probably for next
Agree.
session.
Agree. So I'll take up a roadmap for implementation with the rules. Okay. I'll call out the important points. So that's going to be part 2 of the series whenever we connect again. So again, we will continue the session, and the agenda will be focused on what are the next steps based on the rules for the organization to start working upon. Right. Very valid
Absolutely.
suggestion. Actually, it was part of one of my 3 areas to focus. And I know for sure that when I open these topics, we will not have enough time to cover the roadmap as well. And that is the reason I sort of skipped the topic. And we'll definitely give more focus to the topic so that everyone will again enjoy that session to ask more questions of how do we do it for the organization, right? So thank you for the suggestion, Sarika. We'll definitely take that up. Okay, we'll keep these sessions coming. So this session is not for marketing purposes. I know most of you are engaged with me in the training, and I would like to have this discussion for making the future DPOs of India, right? So this is gonna be a long journey, and we're gonna keep in touch with these regular sessions as much as possible. Yeah,
Absolutely, Jay, absolutely.
I always feel energized to talk to my learners always. Yeah, thank you so much.
Hi Jay, just one feedback for InfoSec train. So
Yes,
this
Aditi.
meeting had a maximum capacity at 100. So I had originally joined the meeting. In the middle, I lost connection. I got kicked out of the meeting, and when I tried to join back, it said they've reached max capacity.
Absolutely true, Aditi. Actually, we would like to say you on that. The reason behind that, we did this first interaction for all of them have been invited, but due to the understanding that what actually we are looking for, we have kept it for the top 100 learners with us. We are having the second episode also. We'll be having a broader audience for that to understand why, because it's just not like that. We don't want it to onboard everyone. It was welcome for everybody. But as you say, it was just in line, first come, first serve basis. So there are a lot of, it shows you a lot of queue was waiting to understand. It also shows the interest to have a discussion with Jay, and also brings to understand that what type of discussion we are actually doing all these days. It really makes us to understand that it's really important to bring to all of you. I mean, if you left a meeting at 45 minutes and immediately you just lost your seat, it shows that 45 people are waiting behind you to just grab that seat. So
Aditi,
we understand that.
Aditi, that was a miss, Aditi. We will ensure that we will have more capacity. I know
Yeah,
for unforeseen reason something like that happens. I feel so that was actually the concept was right. What Anna said, that we wanted to ensure that people were eagerly coming joining the session for knowledge should get this opportunity, right? That was the reason they limited the capacity, not for everyone, but at the same time, what you said is a very valid use case, right? Some unforeseen reason you get lost because of a connection, right? So
but
that's the point. Yeah.
but we'll compensate for Aditi for sure. Aditi, on 28th we have Privacy Day. We'll be getting this video live on LinkedIn, so you can have an interactive video, entire video which we have the sessions today.
Yeah. So this
Yes,
session
definitely.
will be uploaded for sure. Okay.
Yeah.
I request you keep it till the Q&A for everyone so that everyone can hear all those questions, and we will definitely promise you with another session, and we will remove that cap to have more participants to join them. Yeah.
Definitely, definitely. Thank you so much, Jay. Thank you, Anas.
Thank you.
Thank you. Thank you. So Anas,
Thank you,
before
Jay.
we get few questions, we'll call it a day.
I think we are. I think I think we are done for the day today. And it was great having all of you out here. Thank you very much, all of you joining from your busy schedule. But this shows that how vigilant we are when it comes to our country, our data, and regarding its implementation. We'll be bringing similar events very soon for all of you. We'll having more regarding the similar in the timeline for all of you to come and learn with us. also to see how much people are interested with all of you. Thank you, all of you, for joining across the globe, giving up your time to all of us and making us believe that's really important to have such discussions. It was nice having all of you on board together, and we'll be showing, we'll show we come with the biggest time slab for at least 2.5 hours, along with Jay, with a larger audience again, to understand the same, what people are looking for the nation.
Yes.
Yeah. Thank
Thank
you
you
so
so
much.
much. Thank you so much. Thank you so much for joining in. Okay. Pleasure meeting you all.
Yeah.
Okay. Thank you.
Right.
Take care. Thank you. Thank you. Bye.